5 seconds to go. Start. It was next submitted that the charge sheet was filed submitted on 2nd July 2020 and now almost 5 years have passed. Mr. Agarwal's submission was that without blaming anybody for such situation, including a systematic failure, there is no real probability of the trial being concluded in the near future. Asserting that the petitioner's rights cannot be curtailed in this way, he urged the court to consider as to whether the petitioner deserves to be enlarged on bail even otherwise, albeit without fully going into the merits. It was submitted even under specific laws where there are prohibitions for grant of bail unless the court is satisfied that there is no chance of the petitioner being convicted and or it would not otherwise be against public interest. The courts have held that the same would not apply in case of granting provisional bail. It was submitted that such proposition has been dealt with at paragraphs 12 and 13 in Arvind Kejriwal versus Directorate of Enforcement 2024-9 SCC 577. Further, it has been contended that even the petitioner was granted bail by the Delhi High Court or the trial court concerned in a majority out of the total 11 cases. It was urged that the petitioner has been shown to be the villain because he was a ward councillor and naturally people would reach out to him if they required help, including those from his own community during the time of the riots. However, learned senior counsel took the court through the charge sheet, the reading whereof would indicate that the petitioner made repeated calls to the police control room. The police arrived late at the spot, and the petitioner's house was the sole house which was not vandalized. He submitted that even as per the materials, some incriminating articles have been recovered from the petitioner's house, but that would not prove that the petitioner was the mastermind of the entire plot, as was the version of the prosecution. Otherwise, advanced the learned senior counsel in a regular case, the courts have always granted bail to the accused within a few months of incarceration. It was contended that the materials which have been recovered would not disentitle the petitioner from favorable consideration for release on bail. It was submitted that almost 5 years of incarceration have rendered the petitioner out of society and there has been no contact with the electorate, and thus it is all the more reasonable and fair that the petitioner should get a chance for whatever few days remain for the election, such that he can attempt to convince the electorate to exercise their franchise in his favor. Moreover, it was submitted that the petitioner's conduct otherwise prior to the date of the FIRs has remained unquestioned. There are no indications that he is a hardened criminal, for within a few days of the unfortunate incident he was incarcerated. Learned senior counsel stated that prior in time to the riots there is no allegation of the petitioner being a member of or otherwise being involved with any organized gang. Attention was also drawn to the observations made on the petitioner's role by the High Court trial court in the orders which granted him bail. Learned senior counsel submitted that he is tempted in the above backdrop to also go into the main merits, but being conscious that the present petition is only for an interim bail, that too for a specific purpose, he refrains from the same. He submits that his case for regular bail is pending before the High Court, wherein the next date for hearing fixed is 20th February 2025. It was informed in the pending two cases also. The bail applications are next fixed on dates after conclusion of the elections. Per contra, the sole respondent opposed the petition, Mr. S.V. Raju, the learned additional solicitor general, appearing for the respondent, submitted that the present petition is misconceived. It was submitted that when on a specific prayer made before the High Court, custody parole was granted only to fill up and submit his nomination papers, the matter should have attained finality there itself. It was vehemently submitted that the right to contest elections is not a fundamental right, and the fact that the petitioner has been allowed to fill up his nomination form indicates that the High Court was indulgent to allow him to participate in the election, but a right to campaign would not be a necessary corollary to the indulgence granted, for the reason that various other modes of campaigning are available to him apart from physically, for example, by way of pamphlets, etc. Learned ASG submitted that even under the relevant electoral laws, the right to vote is not available to a person who is behind bars. If the petitioner at present behind bars is allowed to come out, he would have a right to vote, which would be an infringement of the statutory provision under Section 62 of the Representation of the People Act 1951, especially Section 62(5). Learned ASG stated that the court should consider the balance of equity between the parties, and in the present case, the same is heavily titled in favor of the prosecution, for reason that in view of the nature of the allegations levelled against the petitioner, his coming out on bail would lead to many other complexities, inasmuch as he would be getting in touch with the witnesses of the cases and would also be in a position to dominate them under the garb of a ward councillor. Moreover, it was submitted that in the larger picture, the court would also consider as to whether inference in the present case would lead to a precedent where similarly situated convicts under trial prisoners just to get out of jail may stand in any election. Learned ASG expressed an apprehension that given the position in our country where elections are held at regular intervals somewhere or the other, chances of misuse of an order of interim bail in the present case are real and not imaginary. It was submitted that if the petitioner is so confident of his work and position in society, he would not be required to physically canvass, and if at all he is the choice of the electorate would be wise enough and vote for him, and then the consequences may follow. Learned ASG has also taken us through various judgments in support of the proposition that the statute prohibits the grant of bail in like cases. Additionally, it was submitted that the present petition had been rendered infructuous and the court could not prejudge the case, more so when the High Court is yet to apply its mind on the merits as the regular bail plea is pending. The learned ASG submitted that the court ought to refrain from granting interim bail to the petitioner, as the same would be purely academic in the background of the petitioner still being in custody in two other cases, including one under the PMLA in which he is unlikely to be granted relief. Stop.